for Eco Talk. I'd like to welcome Dr. John Doherty. He is a science and policy analyst at the Environmental Law Institute here in DC. He works on research and education projects with ELI to advance science-based solutions to climate change and its threats to humans and ecosystems. He acts as the bridge in between science, policy, and law. And I'm really excited to hear what he has to share with us. Thanks so much for being here, John.
All right, well, great. Thank you, Professor Myler, for that introduction. So, Professor Myler, as Jesse indicated, I'm John Doherty. I'm a science and policy analyst at the Environmental Law Institute. ELI is a research, education, publication center here in DC. And my background is actually a little bit of a mixed bag between political science and geoscience. So it's a real delight to be here in the Earth Common for any sense that this kind of sort of transdisciplinary and interdisciplinary work is kind of celebrated. And what I want to do with this presentation over the next hour or so is try to answer this question: what does climate change have to do with the courts? To get there, I'll provide a little bit of an overview of the scope and trends of climate litigation. I'll talk about my interest in this space, which is the role of science in informing these kinds of decisions. I'll do a little bit of a detour to talk about attribution science, what that is, and why people expect that that would be important for informing future climate law and policy. And then I'll close out with a little bit of a plug for one of our programs at ELI that tries to build climate literacy in the judiciary so that judges are prepared to handle these kinds of cases. All right. So over the next few slides, the data that I'm going to show are going to come from Columbia University's Saban Center for Climate Change Law. And this is a plot of climate cases filed over time. In blue is US litigation, and in red is litigation everywhere else in the world. And the trend is pretty clear, right? So since the early 2000s or so, cases related to climate change have really accelerated. Now, they might have tapered off a little bit in the last 2 years, but still sort of a steady stream of cases we're seeing come to the courts. There are two things that are important to say about this database. There are two inclusion criteria for it to be included here. The case has to be brought before a judicial body, and the case has to have climate change law policy or science as a material issue of law or fact. And those are reasonable constraints if you're interested in maintaining a database. But it's not necessarily a comprehensive picture of all the ways that climate change is affecting the legal system, right? So I'll give you an example. I was at a program with a judge from Puerto Rico last year, and she told me that in her jurisdiction alone, Hurricane Maria spawned over 2,000 insurance claims. None of those claims that generated legal disputes would have been included in this database, but they're still important in terms of understanding how climate change is impacting the whole system. This is just a geographic representation of those same data. Again, kind of showing the US as the clear outlier here, over 1,900 climate cases from this definition. But also we're seeing cases in Western Europe, Australia, Brazil, Canada, Mexico, kind of all over the world. This trend is happening. And when we look at where in the US these cases are coming, it's probably not a huge surprise to see California as an outlier. But what I want to stress with this is that really every single state in the US, with the exception of New Hampshire, has seen at least one climate case, where again, climate change is a material issue of science, law, or fact. So what do these cases actually look like? It's actually really kind of hard to define them because there's such a diversity of claims in them. So two big ones are the National Environmental Policy Act, NEPA, and the state level equivalents of those, sometimes called little NEPAs. And these are the laws that govern environmental impact assessment. So that's not a huge surprise. But I also just want to take a minute to appreciate the diversity here, right? Like state utility regulation, public trust, common law, adaptation, constitutional claims, securities and financial regulations, and then of course your run-of-the-mill environmental statutes like the Clean Air Act, Endangered Species Act, and Water Act come up frequently too. And just to drive this point home, in case I haven't already done so, you can certainly think of climate litigation as litigation with climate change as an explicit central or peripheral issue in the case. But some legal scholars have argued, in fact, that you can consider litigation related to climate change more broadly. So you can consider a climate case as litigation with climate change as one motivation, but not necessarily raised as an explicit issue. An example of something like that might be an environmental group bringing a lawsuit against a coal power plant on the grounds of air pollution, but kind of secretly, implicitly motivated by climate change. But another definition here that's offered by these legal scholars is litigation with no specific climate change framing, but with implications for mitigation and adaptation. And if you know about climate change and the way it affects all parts of our society, it's actually kind of difficult to think of what isn't a climate case in this definition, right? But sticking to the Sabin Center definition here, where climate change is explicitly raised as an issue, these are just some examples of trends of high-profile types of cases that we're seeing. So we're seeing suits by state and local governments against fossil fuel companies. A couple of examples that I'll go into later. This area, this county of Multnomah, the Exxon, and municipalities of Puerto Rico, the Exxon. In general, these suits are seeking on the order of billions of dollars of damages against fossil fuel companies for the alleged impacts of climate change in their jurisdiction. We're also seeing suits under state constitutions. So to take just a step back here, 7 states in the US include environmental rights amendments within their constitutions. And the scope and application of those amendments varies, but each kind of guarantees some formulation of the right to a clean and healthy environment. We're seeing a number of lawsuits typically brought by plaintiffs, actually, with the assistance of a nonprofit called Our Children's Trust, against state governments to essentially try to get there and compel their state governments to take additional action on climate. And I'll go into this example of Held v. Montana later on in the presentation. There's 2 other types of trends that we're seeing is challenges related to renewable energy programs and projects will sometimes implicate issues of like the impacts of building out renewables on wildlife and economic issues associated with renewables. We're also seeing challenges to federal climate regulations and maybe the lack thereof in the coming few years, including the climate disclosure rule proposed by the SEC and other vehicle emissions rules by EPA and the National Highway Transportation Safety Agency. So before I go on, I do want to get to the role of science here, but are there any questions on that portion of the presentation? Yes, sir.
Do those numbers in your database, do those cases include cases that were brought by folks who are not accepting the science of climate change, say trying to like invalidate some kind of policy or
Yep.
oversight?
It does. There are a minority of cases like that, but those are certainly in there. Lawsuits that are seeking sort of usually like FOIA claims against university professors for their data, trying to argue that there's some covering up of climate change and it's not a real problem. Those are certainly in there, but they're a minority of the cases. Yes.
Is there any explanation for why the cases have tapered off in 2 years or so?
Yeah, it's a good question. I don't know. I'm sure people have speculated about it, but I haven't thought about it myself. One explanation might just be because cases take a while to proceed through the legal system. So even though there's been a drop off of the cases filed, those cases that were filed in years previous are still making their way through the courts. So that might have something to do with it. Okay. So what does science have to do with all of this? The paper that really kind of sparked my interest in this was published by Sabrina McCormick over at GW in 2017. And what McCormick and colleagues did was they went through hundreds of decided climate cases and they qualitatively kind of assessed the importance of science, how important science was in coming to the judge's decision in that case. And there are interesting things to say about her data set, including the fact that sort of different types of climate cases supported more or less different types of science. But what was really interesting to me were 2 of her general takeaways here. The first is that she says, generally, science is raised more in cases brought with a pro-regulatory goal than an anti-regulatory goal. That is, in cases where plaintiffs are essentially trying to get their governments to act on climate. And the second thing she says is that novel legal theories are emerging in an effort to use available climate science in ways that increase the likelihood of the success of these lawsuits. So in other words, science tends to be really central to the arguments for advocates of climate action. And Sabrina McCormick argues that the science and the law are starting to kind of evolve together in ways that she thinks will make these cases more successful. So with that backdrop in mind, my colleagues and I wanted to take sort of a deeper dive into the cases in 7 of these states. And we selected these states because each of these, well, first, they're environmentally diverse and somewhat politically diverse as well. But each of them also contains an environmental rights amendment in their constitutions, which tends to be invoked in arguments that support high levels of compliance. And our goal here with this project was to quantify the judicial engagement with both the individual scientific topics that were coming up in these lawsuits, but also the sources that were being cited by the judges. And so what we did was we read a whole bunch of opinions, decisions, orders, basically any document that a judge had authored in one of these cases we read, and we categorized their quotations of technical information into both the topic of that technical information and a source that they cited to. So over the next couple of slides, I'll show some data from this project. These are heat maps with the horizontal axis showing the state and the vertical axis here showing the topics. On the next slide, it'll be the source of science. One thing to say right off the bat here is that Montana is going to be an outlier in both of these. Here you can kind of clearly see this dark blue under local climate impacts. I'm not sure if the highlight function will be here. But yeah, so you can see that this is sort of an outlier in the state of Montana. And this is all driven by one case, actually, Held versus Montana, which is that youth-led constitutional case I mentioned earlier on. So just to flag that up front. Across the board, we generally found that energy topics tended to come up quite a lot. In states that are leading in emissions reductions and actually have sort of emissions reductions targets on the books, like Hawaii, Massachusetts, and New York, we found that greenhouse gas accounting, really kind of quantifying the emissions and progress in emissions reductions were important. We found that local climate impacts, yes, of course, in Montana are important, but also in states like Hawaii and Rhode Island, and we hypothesized this because they're pretty small coastal states with sensitivity to acute climate impacts like sea level rise and flooding. And we found this noticeable gap in attribution science. So this is the body of research that quantitatively characterizes the emissions of a source and links it to climate change and harms on the ground. And legal scholars have kind of speculated for a while that this field would become important for informing climate litigation, and it certainly is in a certain type of case, but it's not really invoked so much in these sort of run-of-the-mill cases that we've investigated for this project. Moving on to sources now. We found that advocacy and non-professional sources are actually kind of by far the highest cited sources of science by judges. And this category includes court documents submitted by the legal parties, so plaintiffs and defendants are submitting a complaint to initiate a case. Defendant typically files a motion to dismiss or some kind of other argument to counter the plaintiff's argument. And judges themselves, by definition, are tasked with making decisions based on these documents. So it might not be surprising at face value to see this as a major source of their information, but these were only classified this way if we couldn't identify a primary source of the science. So in other words, what this actually means is that a lot of these science-based arguments that plaintiffs and defendants are both introducing are not actually citing two original scientific sources. When they do cite two original sources, we found that local and state government sources tend to be important. It's not too surprising. These are state court judges that are deciding matters of state law and policy. So, of course, they would be citing their governmental counterparts here. This was kind of a disappointing finding to me, and I'm sure to many in the room. Consensus reports, like the IPCC reports, the National Climate Assessment, and the academic peer-reviewed literature are actually really rare in these kinds of documents. And this, of course, is the gold standard of academic research and scientific research. So it was kind of sad and disappointing to see it not have a large presence in reports. So I want to get back to this outlier, Held versus Montana, for just a minute, because it really kind of is an anomaly in the world of climate litigation and the role of science in climate litigation. So at issue in this case was a provision of Montana's environmental review law, the Montana Environmental Protection Act. And the provision basically said that you can't look at the emissions, the impacts of emissions of greenhouse gases when doing your environmental reviews. So for other words, if you have to build something and do a development related project and do an environmental impact assessment related to that, you can't look at the impacts, you can't consider the impacts of greenhouse gas emissions on the environment. But remember that Montana's constitution is one that includes the right to a clean and healthful environment. And it actually includes this for both present and future generations too. So a trial court judge reviewed plaintiff's suit over this and said this NEPA provision was against the Constitution. And a trial court judge agreed with them. She said, yeah, it's unconstitutional. This is against the Environmental Rights Amendment in Montana's Constitution. And I think because it's a little easy to kind of view this as abstract and not sort of having a concrete impact on the ground, but the facts is that this decision informed also a separate dispute about an air permit for a gas plant in Montana. And now the state's Department of Environmental Quality is also updating its rules to study the impacts of greenhouse gas emissions. This decision was appealed by the state to the Supreme Court of Montana, but last month in a 6-1 decision, the Supreme Court of Montana affirmed the trial court judge's opinion, and so this is now the law of the land in Montana. And why I said this was kind of an outlier is that this decision, if you read it in Held, is really it's remarkable. It's 103 pages long, and about 90 of those pages is a scientific report of how climate change is affecting Montanans. So these are just a couple of kind of examples of economic impacts that the judge highlighted in her decision. So first, she found that climate change is making the impacts of wildfires in the state worse, which is leading to closed businesses and roads, fewer customers, and reduced economic profits for Montanans and their families that rely on them. She also similarly found that climate change is causing reduced snowpack in the state of Montana, which was having negative effects on the ranching industry and similarly reduced profits for Montanans. So just some general takeaways from this section. We found that in the liberal states that actually have sort of climate targets on the book, we found that scientific information plays a key role in informing sort of the nitty-gritty details of the energy transition, tracking progress on emissions reductions, actually sort of identifying and overcoming the issues with building out renewables. In the two, I'll call them less liberal states, Pennsylvania and Montana, we found that science is generally used to inform arguments that seek to compel their state governments to take additional action or any action on greenhouse gas emissions, which include either just analyzing them or more pointedly reducing them. We found that cited scientific content in these lawsuits does not necessarily originate from scientifically vetted sources. I didn't show these data here, but we also looked at a subset of 12 science-heavy cases. And we found that in 10 out of 12 of these cases, they resulted in an outcome that we call sort of pro-climate. In other words, expanding clean energy access or analyzing or actually reducing greenhouse gas emissions. And again, this limited role of formal climate attribution science, which I'll go into more detail on the next section, but wanted to just highlight that legal scholars have identified this as a real sort of evidentiary gap, is what they call it. And I'll spare you from reading this entire abstract, but if you just look at the highlighted part at the bottom, they do conclude that a greater appreciation of this body of research could reduce barriers to climate litigation in the favor of plaintiffs that are advocating for climate action. Okay, so I've been talking around attribution science this whole time, and I want to go into a little bit more detail on what I mean by attribution science and why people think it's important in this world. But just wanted to pause one more time to see if there might be any questions. Yes.
How does the relationship between causation and correlation in science match or differ from the relationship of those two concepts in the law?
Yeah, that's a great question. I think it'll become more clear in the next section, but this is a great point to keep me up into this attribution science.
Okay, cool.
Any other questions? Yes.
Could you notice a trend between the topic sources used in court and the success rate of that case? So were certain cases more successful because they use that particular source?
Yeah, we didn't look into that. That's a good thought though. I'm gonna look into that a little bit more. Thank you. Okay, so attribution science, what is it? When we talk about attribution science, there are generally four bodies of research that people are referring to that together provide a causal nexus between the emissions of a given source and the impacts of climate change on the ground. So starting on the right-hand side here, the source and global climate change attribution, these two bodies of research are typically linked. And what they're concerned with is investigating the emissions of a given source and the effects of those emissions on a change in the global climate system. So that could be an increase in global mean surface temperature, it could be a reduction in sea ice in the Arctic, it could be an increase in global mean sea level rise, or pick your global climate variable of choice. And source can be defined very broadly. It could be like all of human activity, the emissions from all of human activity. Or it could be, as some lawsuits are arguing, the emissions of individual companies or sectors. It could also be nations or states, or sort of however you'd like to identify your source. So the next step in this sort of causal chain is to look then at the impacts of global climate change, a change in the global climate system, from those emissions on weather, right? So weather events, including their extremes like a heat wave or flood or wildfire, looking at the additional sort of intensity or likelihood change that was caused by climate change. So an example of like an event attribution question might be how much more likely was that heat wave made due to climate change, for example. And then all the way at the other end of the causal chain is impact attribution. And this is really isolating the impacts on the ground on people and ecosystems and economies of that event due to climate change. So an example of an impact attribution question would be, what was the additional economic damage due to that flood that was being worked by a baseline increase in sea level rise, again, all the way tying it back to global climate change due to the emissions of that particular actor or set of actors. And the reason why people think this is important for litigation is that advocates are attempting to use this body of science to assign liability in various ways to actors. So, for example, sports and climate change attribution, scholars have speculated could be important for cases that attempt to hold sources liable for the impacts of climate change, generally cases against the fossil fuel industry. They've speculated that impact attribution could become important for identifying what is reasonably foreseeable under the law. So, for example, if a 1 in 1,000 year event is now happening in 10 years, what does that mean for reasonable foreseeability of risk, right? And then event attribution is coming up in a couple of cases that center the impact of climate change on individual extreme weather events. So one in County of Multnomah from the heat wave in 2021, and one in municipalities of Puerto Rico, which centers the 2017 hurricane season and the impacts of Hurricane Maria. And just kind of taking a step back here, there are really two questions that attribution science can answer. So it's really tempting to ask, like, did climate change cause that event to happen? But that's kind of the wrong question to ask. We can ask if climate change affected the likelihood of an event, or we could ask if climate change affected the intensity of an event. And these are actually kind of two sides of the same statistical coin, because the way that this works is that if you imagine the bell curve of temperature distribution shifting to the right with climate change you'll find that you get both more hot weather, but also hotter hot weather, right? So you're affecting both the likelihood and the intensity. As I mentioned on the former slide, these kinds of event attribution studies are coming up in Oregon, County of Multnomah, the Exxon, and Puerto Rico, municipalities of Puerto Rico, the Exxon, where these two governments and sets of governments are suing a set of large fossil fuel companies for damages that they've identified regularly to climate change, suing on the order of tens of billions of dollars, over 50 billion in Oregon, for example, and this money is intended to both sort of help the populations recover from the impacts of those events, but also prepare for additional extreme events of this nature that are going to become more frequent and more intense with climate change. As you can imagine, industry is pushing back on these claims. A number of arguments that they've raised are here, and they touch on both sort of attribution science itself and what I'll call the underlying philosophy of attribution science. So, for example, in the heat wave case in Multnomah, the defendants have raised the question, can emissions even legally be attributed to the source, given that greenhouse gas emissions are well mixed in the atmosphere? And if so, what's the most appropriate accounting method, right? So a lot of these lawsuits actually rely on one single analysis by Richard Heath of the Climate Accountability Institute. And he published this paper in 2014, arguing that a small set of companies bore responsibility for a large percentage of global greenhouse gas emissions. But intrinsic in Heath's analysis is the assumption that these companies bear responsibility, exclusive responsibility, for all of the emissions that are embodied in the product, right? So in other words, the defendants, the fossil fuel companies, are asking the question, well, if you're gonna hold us liable for climate change, what about the individual gas station operator, right? What about the driver of the vehicle that has a gas combustion engine? Are they also liable for climate change? Another question that came up that touches on these topics was patent held. So this is kind of interesting. Montana's government is very conservative, and many people kind of thought that when this case went to trial, Montana would dismiss the science of climate change. And indeed, they originally didn't have the climate denier as an expert witness, but they pulled her at the last minute. And instead, the only and the main factual argument that they advanced at trial was just that their state's emissions are too small to matter. So they accepted the full body of science. They accepted that climate change is real. They accepted that it's human caused, and they accepted that it has negative impacts on Montana. And they said, you know what? All that's true, but if we stopped emitting, if Montana altogether stopped emitting, it wouldn't make a dent in the global mean surface temperature. Obviously, that was not a convincing argument to the trial judge or the Supreme Court justices, but that was the main argument that they tried to do. Whenever one of the cases against the industry is filed in state courts, their sort of immediate response is to remove it to the federal court system. And that's because, based on current Supreme Court precedent, the industry believes, I think rightfully so, that they'll find more success in federal courts. But so far, when they've tried to do this repeatedly, the federal courts have sent them all back to state courts. So they've never made a convincing argument to the federal courts that they belong there, not the state courts. But there was a recent question that went to the US Supreme Court last year out of one of these cases, City and County of Honolulu versus Sunoco. And they asked the question basically, can big groups even hear these cases at all? Last year, the Supreme Court asked for the opinion of then the Biden administration Solicitor General, who argued for keeping the cases in state court. And just a few weeks ago, the Supreme Court did refuse to take up these cases. So, in other words, they are all being sent back to the state courts from which they originate. This is a presentation about the courts, but I did just want to note quickly that attribution science is also coming up in legislatures. So a number of states, New York and Vermont, have enacted what are called climate superfund bills. And similar bills are being considered in California, Massachusetts, and Maryland. And these are bills that are based on CERCLA, the federal superfund law that assigns strict liability to persons that are identified to contribute to hazardous waste, and then they have to pay into a fund that supports cleanup efforts of that hazardous waste. So this kind of follows similar logic in that these bills just kind of automatically hold large fossil fuel companies responsible for the impacts of climate change. And assigns liability to them to pay into a fund that support developing climate change adaptive infrastructure. So there are two of these bills that are on the books now. Vermont has an asterisk because it's pending a lawsuit brought by the Chamber of Commerce and the American Petroleum Institute. I'd be shocked if New York didn't face a similar lawsuit very soon. But who's liable are entities that are deemed responsible for over 1 billion metric tons of carbon dioxide equivalent emissions over a specified time interval. Time interval is a little bit different between New York and Vermont, but not much. New York has identified $75 billion worth of damages, and it's kind of interesting if you read the legislative findings that precede the text of New York's bill. They actually make kind of a big deal in saying that, you know, the damages from climate change to New York are easily going to exceed hundreds of billions of dollars. So this $75 billion figure is actually kind of a drop in the bucket for the full damages. This is in contrast with Vermont, which is currently consulting with attribution scientists to do a comprehensive assessment of damages. So I pose this question up front: what does climate change have to do with the courts? And I hope I've convinced you by now quite a lot. And sort of the next question that you could ask is, what's a judge to do, right? Judges are lawyers by training. They generally don't have an interest in science. Many of them joke that they ran away from science to go into law. And so, you know, all this technical information is coming at them. It's high stakes cases. They need some information, right? Some neutral, objective information about basic science, climate change. And that's what our project aims to do, the Climate Judiciary Project. I like to consider us as having 3 arms: a research arm, which is what I'm talking to you about today, a programs arm where we put on and consult with institutions to do judicial education programs about climate science and the law. And we also publish a written curriculum that's co-authored by both leading climate scientists and legal scholars in their field to explore various topics related to climate change and how it's coming up in the legal system. I wish I could stand before you and take credit for all of these reviews of our programs, but it's really thanks to a wide variety of excellent partners on both the science and the law side of things. Perhaps our sort of flagship program is called the Judicial Leaders in Climate Science. And this is a year-long course that we do in collaboration with Woods Hole Oceanographic Institution and the National Judicial College, which is outside of the University of Nevada at Reno. And it's a year-long program for judges to learn about climate science, but also leadership, with the idea being that they'll take their skills in leadership and their knowledge of climate science to go and do programs in their home jurisdictions. So it's kind of a train the trainers program, and one that we've found to be just remarkably successful for meeting a wide variety of different jurisdictions that might be kind of at face value averse to learning about climate science. We also publish this curriculum. As it stands, we have 13 modules, which are white papers that are all peer-reviewed by experts in the field. They're also typically reviewed by a judge at the end and edited by us. And we're looking to expand this. We have plans in the works to develop modules on energy. We have plans to publish one on sea level rise, hopefully in the next few weeks. And we're also exploring a topic of climate and health in future modules. So that's all kind of on the horizon for us. And those modules are freely available at our website, cjp.eli.org. They're written for judges as the primary audience, but I would say honestly, like, they're useful for anyone who's interested in an introduction to this topic. So if you'd like to learn more, please feel free to check them out. Or you can get in touch with me at darty@eli.org. And with that, I'd be happy to take any more questions.
Hi, you mentioned that 7 states or so have built into their state constitution this idea around clean and healthful environment. And I was thinking about under the Clean Air Act, there's an endangerment finding, greenhouse gases endanger public health and welfare. So the term public health and welfare seems a little similar to clean and healthful environment. And then broadening that out and looking at other countries where France and South America countries have embedded in their constitution, sort of this fundamental human right that has allowed sort of the compelling of the state to act in this space. And probably a big leap, but as a lawyer, I'll make the leap to sort of think about life, liberty, or property under our Constitution as to whether that might even more broadly encompass the right to regulate for greenhouse gases. But I'm wondering if ELI has sort of surveyed across that type of field, a pretty broad field, to sort of further enhance the arguments that the Clean Air Act or the US Constitution actually provides the authority, as an EPA attorney, I'd like that it does, but also compels the agencies of the federal government to regulate.
Yeah, it's a great point and question. I'll just say ELI itself, we don't advocate, so we don't make these arguments ourselves. But they have been made certainly. And in one case in Hawaii, a judge actually wrote a concurring opinion for one of these cases saying that the right to a clean, stable climate system is included in due process, right? Constitutional rights, what you're talking about.
Right.
So you don't even need these clean, it's helpful, clean environment provisions of the Constitution. It's just due process. Other people have argued under the public trust doctrine in states where they don't have these constitutional provisions, but they haven't been successful in court.
That was a Hawaii court you mentioned?
Hawaii, yeah. Yes.
So Montana's defense is sort of interesting. I wondered if you could tell us more about how you see that kind of counterfactual argument fitting with the debates about attribution science. So essentially they said, well, even if Montana had, even if we stopped, I guess they said if we stopped today, it wouldn't make a dent. But imagine like applying the same thing to, if Exxon had stopped producing oil at the point where their own internal memos revealed that they knew what was going on. I mean, that would potentially actually build their liability.
Yeah.
And so I guess I just wondered if you know more about how those kind of counterfactual scenarios are being constructed both in the climate attribution science and in the courts.
Yeah, thank you. It'll all depend on what the judge finds convincing, to be honest, because like, yes, if you just look at the emissions and accept these numbers of the emissions at face value, you can do that kind of attribution against. But the deeper question that these companies are trying to assert is like, look, we don't have responsibility for all of the emissions embedded in our products. It's you consumers, right, that are using the fossil fuels and we're just producing them and providing them. Now, there have been arguments that have developed on like deception grounds that might get around that are essentially pointing to historical and scientific literature that they claim, Exxon actually knew about the danger of climate change and failed to act, which might be a deception claim. But again, these cases haven't been litigated yet, so it'll all kind of depend on the law is brand new to this space, and we're still kind of watching how it evolves and what happens. Yes.
I'd be curious if you could explain more about how the courts are trying to deal, or people are trying to argue about future emissions and those impacts in the courts, because at least my understanding is, like in court, it's usually about a past injury that you're bringing. So how can a lawyer come to the court and say, this is going to happen in the future, but it hasn't yet?
Yeah,
And have a judge make a
that's
decision
a
like that.
great question, and if I can go back to Montana here. So this is why I thought this was kind of interesting, this provision of the Montana Environmental Rights Amendment is that it guarantees this right to present and future generations. Not every amendment does that, but because the things that fit Montana, they're able to make that argument legally that we're concerned here about future generations as well, and climate change is gonna have an impact with them on them.
But if they're somewhere where there's not like a provision of future generations, then you can't really make that argument.
People have tried to make it, I think it'd be less convincing than if it's actually written into the Constitution like it is in Montana, but people have tried to make those arguments. Yes, so the gentleman first.
I'll be you by a second. Thanks for the talk. It was wonderful. I'm wondering, what's your sense of how much these decisions are impacted by specific judges and justices? And if that's the case, do you get the sense that a future generation of judges and justices who may have been holistically educated around climate change might impact the direction that climate change is headed in the courts?
I think that's exactly right. It doesn't always fall to the individual judge, because these high stakes cases are always appealed. And sometimes appealed all the way to the federal Supreme Court. So there's always like layers of appellate courts that get involved. But I think you're absolutely right that judges of the new generation that are more mindful of climate change might have a different take on a judge who is close to retirement age that never heard of climate change outside of reading it in a Fox News article. So, yeah.
So maybe kind of on a parallel line, it seems like especially in Montana, right, having some constitutional wording in there has really helped as sort of an umbrella term that can be applied to a lot of different environmental impacts. And as we move forward, an existential concern of mine is that it's often difficult to know, in 50 years, what the major environmental impactors will be, right? In the 90s, we were worried about the ozone layer. Now we're worried about climate change. These things kind of come out of the woodworks. So from a more policy and government focused perspective, do you have a sense of how, we can start thinking about laws right now that will provide a more blanket cover for these future uncertainties?
Yeah, and you're putting your finger on exactly what Montana did. So this amendment is actually from the 1970s. And they didn't know anything about, really anything about climate change. And weren't concerned about it, certainly. So the fact that they're able to leverage that sort of long-standing will of Montanans back in the 1970s that put this in the Constitution to address climate change is kind of remarkable. And I think there is hope for that kind of logic to carry over to any future environmental challenges. I think other states are also kind of seeing the importance of these. So Maryland, I know, and I think a handful of others are exploring the option of including similar amendments in their state constitutions. Yes.
So in the cases you looked at, like how did they define future when they said that will have like a climate impact? Is it like 10 years, 15 years, or 50 years, or what pathway for the IPCC?
Yeah, I'd have to go back to the complaint and the decision to give you specifics, but in general, I think they highlight like the IPCC pathways that go out to 2100. So they'll talk about like an extreme scenario, or CP 8.5 scenario, going out to 2100, and the different impacts that's projected to have on climate. But yeah. Yes, in the back there.
Hi, yeah, thank you so much for the talk. I just had a question about, has science been used by some in these cases, like against like pro-regulation in any way? I know that you said that in the one study, it was mostly pro-regulation, but like has like science or like lack of science ever been used as like a kind of an against for like environmental regulation?
Yeah, I think so, and I think that touches on what I was trying to make at the end here about these counter arguments about like source attribution. So depending on the way that you want to identify the source, you'll have differences in the outcome of their responsibility for climate change. And if that's up for kind of legal debate, then these companies can get off the hook and say, look, there's not agreed upon science to support these claims. I think it could be the case that particularly under cases that rely on individual event attribution, like Multnomah and Puerto Rico, it's conceivable to me that that science itself can be contested. I think less so in County of Multnomah, actually, because I glossed over this, but this was about a 2021 Pacific wave that was really unprecedented in the history that anyone's seen in the region. So it killed hundreds of people across the US and Canada. And there was one study that found that it was, quote, virtually impossible to have occurred without climate change. Other studies have kind of come out and reduced that likelihood estimate, but no study has like found that climate change didn't have anything to do with that. All of them identify role climate change. So I think that one's on pretty firm ground. But the case in Puerto Rico, there's only really one study that looks at the impact of precipitation increases due to climate change and Hurricane Maria. And so that is on a little bit, I would say, shakier scientific ground. And it's conceivable to me that defendants could kind of like poke holes in that article itself, even though it's peer reviewed. research article. Yes.
General Assembly asked the International Court of Justice to shed light on the obligations of states vis-à-vis climate protection. Do you know what progress has been achieved?
Yes, let me think, I do remember hearing and reading about this, but I know it's not coming to me immediately. Yeah, it's the human rights court, right? Let me look into that. I haven't been following that as closely. Sorry for that, but I'm gonna look into that. The other thing is like, I do a lot of work in US courts, and these international holdings are important for European bodies and bodies around the world, but they tend to be less important for US judges and US courts. So they're important for like the global climate picture, but not super important for the US. And I wanted to get back to you, sorry.
Yeah, thanks. I wonder if you could say a little more about the remedies that are sought here. So clearly, like the strategy seems to be, you can't put the, climate change on trial writ large, but you can pick a piece of it and then open up the possibility of introducing climate change science into the conversation. How much do plaintiffs pay attention to the remedy that they're seeking? And have you seen any assessment of the effectiveness at all of those remedies on impacting climate change in a positive way?
Yeah, so the remedies piece is interesting. This kind of goes back to the New York and Vermont Superfund bill. So New York is basically just pulled this number from Mike and out of thin air, like didn't do any assessment about like they had numbers about the impacts of climate change in New York, and they decided not to use that information when they came up to this figure of $75 billion. Vermont, as I mentioned, is doing this comprehensive impact assessment with scientists that are looking at the impacts of flooding and projecting what that's going to look like out into the future under climate change, and trying to make the argument that these companies bear responsibility for paying into a fund that will allow them to develop the necessary infrastructure to withstand events of that nature going forward. Does that answer your question?
Yeah, I guess, I mean, would you deem those kinds of remedies sufficient to actually get at the issues that are driving climate change and the alarms that, by the way, a yellow thing keeps showing temperature warning up there, which is kind of cool. But that was part of your, it comes on and off. Maybe as your argument gets more heated, but I just wonder if you deem those remedies sufficient to actually get at the drivers and the core issues of climate change, or is it just like trying to, corporations are essentially able to pay to play in this context?
Well, it's not a trivial amount of money. So Oklahoma is seeking over $50 billion in damages in that one county in Oregon. So if these cases are green lighted, they will be on the hook for potentially hundreds of billions of dollars, which is a pretty good incentive to change behaviors, right?
Yes.
So not in isolation, it's not going to solve climate change, but the plaintiffs that are bringing these cases certainly think that it's going to make a difference.
And they're conscious of that as they shape the arguments and ask for the remedies. They're thinking through that lens.
I think so.
Okay. Thanks.
Ask a question about the practical side of your work, talking with judges. So, correct me if I'm wrong. Most judges don't write their own material, right? They have a bunch of clerks that do the writing.
Yeah.
And so I wondered like what the implications of that are in terms of getting climate science, not just attribution science, but other elements of climate science into judges' decisions, and what your sense is, maybe from talking to judges, about how much they would kind of accept it if a clerk who was really well versed in this brought that in, versus how much the judge would say like, absolutely not, we can't do that, or how much the judge would affirmatively push the clerks to actually bring that in. So I guess it's about how much power the clerks would have.
As I understand it, and I probably should have made this disclosure up front, but I'm not a lawyer. My background's in climate science and political science. But as I understand it, clerks tend to have a lot of power in shaping those kinds of decisions. They're also on the underside. They're generally like just out of law school, these clerks. And so they'll probably have more familiarity with climate science. They've probably seen it in school in recent years. So I think they'd be more receptive to it generally as audience than judges. It's funny, we actually had a conversation as a group about potentially doing a program for law clerks really difficult to do programs with law firms because there's no like lists of folks in the same way that we have networks of judges and they're public figures and they're publicly elected. And they're institutions that do judicial education that we create through channels of. The same thing doesn't exist for clerks, but I think it would be great if it did, and if we could kind of reach that audience in addition to the judges themselves. Yes.
There's more and more work on downscaling climate impacts to very, very local levels. And I'm wondering if you're seeing that come up in the cases where you can say, you know, this specific neighborhood is going to have more
Yeah.
floods, and whether you're seeing that more and more, or if you think that's an area that's, you know, there should be more research in the direction. And if not, also just if you could give advice to climate scientists, what kind of research would you like to see more of that would support these?
Yeah, what you're describing is impact attribution research, and the field has been moving more in that direction. Michael Muir is a real leader in this field, and he's done interesting work on flooding impacts of climate change. And going into, in some cases, like the neighborhood scale level of calculating like X amount of additional houses were flooded due to sea level rise because of enhanced precipitation during the storm. Yeah, so that work is all heading, I think, in a promising direction. And even beyond like informing litigation, that kind of work is really useful just for like practical decision making around adaptation. Like knowing if your neighborhood is really going to be at risk in the future because climate change is, I think, helpful. NOAA had a program which I'm guessing is probably going to cease to exist, but looking at sort of these similar questions and operationalizing attribution science and putting it into weather prediction centers for heat waves and for droughts and floods and things of that nature. So there are definitely people thinking about that. I don't know that it's going to be sort of a government initiative going forward, but there's certainly the scientific community.
We have time for one more question.
Yeah.
This is really great work and I really appreciate the talk. It's been really fantastic. This is, all of your work is centered around legal cases in courts. Do you know of anyone who is doing similar work related to the drafting, debate, and passing of legislation?
Outside of these climate superfund bills, I think this is kind of at the forefront of utilizing this climate science legislation. We'll see if, again, Vermont's under lawsuit by U.S. Chamber of Commerce and the American Petroleum Institute that are arguing that these laws are just unconstitutional and preempted by the Clean Air Act and a bunch of other claims. So we'll see if Vermont is able to go forward. If it does go forward, I imagine that lots of other states that are interested in holding fossil companies liable for climate change will be passing similar bills. Yeah, I think that's kind of my understanding of where the legislature angle is on this.
Great. We want to end there, but say thank you to John. Around for a couple minutes to answer questions too. Thank you all for joining.
The National Association of Clean Air Agencies, or NACA, ACAA,
Sorry.
cloud model, state bills, regulations.